Good morning, teacher. Thank you for the meeting today. My name is Fangzheng and my SIMID is S4156962. Today I'll briefly explain the key legal issues affecting LionCare and what they mean for your business. Issue 1. The Staff Retention Fund and Management Conduct. First, the Staff Retention and Performance Fund. Management set aside $18 million from provider fees to pay bonuses to senior staff, including themselves. However, the board never formally approved this decision. Under the Companies Act 1967, directors must act honestly and in the best interest of the company. They also cannot use their position for personal benefit. Here there are two main concerns: lack of proper approval. The board only discussed the idea but did not approve it formally. 2. Possibly menace of company funds. The fund appears to benefit management personally. There are also a shareholder risk. Minority shareholders may argue that this decision unfairly benefits the majority of management. Under Sector 216 of the Companies Act, they can claim oppression if their interests are ignored or unfairly harmed. For example, if company money is diverted to personal gain instead of business purposes, the court may intervene. Issue 2. Urgent capital raising. LionCare needs to raise up to $220 million urgently. There are three options, each with legal implications. Option 1. Bank loan with security. Banks are willing to lend money if LionCare provides security over its assets. This means creating fixed and floating charges, which are legal rights over company property. A fixed charge applies to specific assets like buildings or equipment. A floating charge applies to changing assets like inventory. Under Singapore law, these charges must be registered with ACRA within 30 days. If not registered, the security may become invalid and the bank become an insecure creditor. This is risky because in insolvency, unsecured creditors are paid last. Option B. Convertible notes. Meridian proposed investing through convertible notes. While this provides funding, it raises control concern. The proposal allows Meridian's nominee director to lead a founding committee with power over major financial decisions. This may shift control away from the board and disadvantage other shareholders. Under company law principles, director must act independently. Decisions should not unfairly favor one shareholder. This could again lead to claim of unfair prejudice under Sector 216. Option C. Financial product distribution. The third option involves promoting investment product to customers. This raises issue under the Securities and Future Act and financial advisory regulations. LionCare may need a financial advisory license or operate under a licensed provider. These are also strict duties, including ensuring products are suitable for customers, avoiding misleading statements like calling products safe. If these rules are breached, LionCare may face regulatory penalties and reputational damage. Overall conclusion: the staff fund raises serious concern about director misconduct and shareholder fairness. The fund option involves legal risk, insecurity, control, and compliance. This is a strong need to improve corporate governance and decision-making process. My recommendation is ensure proper board approval for all major decisions, avoid conflict of interest, carefully assess funding option to balance control, risk, and compliance. While LionCare has variable options, careful legal and government steps are essential to avoid liability and protect shareholders' interest. Thank you, and I'm very happy to clarify any parts.